Thanks, Janet. Thanks. And our final presenter for this afternoon is Professor Surya Deva via Skype. Surya, the floor is yours. Good to see you.
Thanks, Mark. Can you hear me?
Yes, we can. Yes, we can.
Okay, very good. Thank you. So, good afternoon, everyone, and it's good to see all of you via the latest technology. I'm going to talk about, in the brief time that I have, about the issue about the liability of the parent company, and I think that issue was already being discussed by Speaker Zadine. So I'm going to focus in particular on the recent Court of Appeal judgment in the Chandler case, and I will assess that to what extent this is a right approach or should we go further with this approach. Let me start by making the background a little bit, that whenever we talk about profit maximization, this sort of facilitates or promotes companies to outsource risk or externalize risk. And outsourcing happens when companies use, for instance, suppliers. This is very common. And when we talk about externalizing risk, that is done in many cases through subsidiaries. So I'm going to focus on one aspect of it, not outsourcing, which is done by suppliers, but I think similar issues do arise in that context as well. But I'm going to focus only on the subsidiary aspect. Now, if we look at the current principles of corporate law, twin principles, and I'm sure all of you are familiar with those principles. The first one is the separate personality of the companies, whether subsidiary or the parent, and the second that flows from it is the limited liability. Now, these two principles are sort of very much entrenched in the corporate law, in both civil law and common law jurisdictions. There are certain exceptions, of course, but in many cases, these main principles still hold very true. And very recently, I was at this forum on business and human rights, and I would like to bring in back what was mentioned there by the one of the I think it was Secretary General of the International Organization of Employers. So it's a very influential body of companies operating all over the world. And a specific point was made by that person that why should we sue the parent company? Because parent company is a different entity, and that's why we should not go after the parent. And if wrong is done by the subsidiary, we should just go and seek the remedy against the subsidiary company. I think in this context, it is necessary to consider very briefly why do we need to sue parent company in certain situations. First of all, there could be some economic reasons. The economic reasons could be that the subsidiary is underfunded. It does not have the resources, especially the mass tort cases, those issues will come. Or there could be a situation that you go for the deeper pockets. There could be incentives for plaintiffs to sue companies, the parent company in particular, in those jurisdictions where the compensation could be more. Then, if you look at the how the interrelationship is there between the parent and subsidiary, there are governance issues. So, to an outsider, it might be difficult to find out where the wrong lies. Is it the decision taken by the subsidiary or the parent company? And that's why there is always this temptation to go after the parent company. Then I think in terms of fault as well as ethical norms, it makes sense. If the decisions have been taken by the parent company, it makes sense to make the parent company accountable rather than merely going after the subsidiary company in that particular sense. And finally, from the policy point of view, I think it would be useful if we could make the parent company accountable, because that is going to send some incentive to the disincentives, and they should manage their affairs better in that particular context. Now, traditionally, there are several principles that are invoked to hold the parent company liable. It could be the agency principle, it could be the vicarious liability, it could be the situations of invoking enterprise theory. But most common is the veil piercing jurisprudence. However, in practice, piercing the veil has been very difficult, and it has been more difficult. There have been some research done empirically on this issue. It has been more difficult in tort cases as compared to corporate law cases or tax evasion cases. So when it comes to uh, issues that we are dealing with, environmental pollution or mitigation of climate change and all these issues, veil piercing becomes more difficult, and that will hold also, in my view, in human rights cases. But it's not merely that, because even the courts have been very inconsistent in applying veil piercing, and that's why it is difficult for lawyers to advise the clients whether they can get veil pierced or not. So it is really very half-edged, inconsistent judicial approach so far, and I think it is also inefficient, because whenever this argument of veil piercing is made, it might take years. So every time we are litigating, and the facts of every case are different, and that's why this is also sort of very inefficient. So in my view, we need to look beyond this. So against this background, we can look at the Chandler judgment, the Court of Appeal judgment, and very briefly the facts of this case. Cape is sort of a very well-known company, because there are many cases involving Cape, but in this more recent case, it's about asbestos business of Cape subsidiary, Cape Products. And this person, the plaintiff, Mr. Chandler, who worked with the subsidiary for a short period of time, about 16 to 18 months, I believe, and long time ago, it was 1960s that he worked. And because he was exposed to asbestos, then he suffered from this illness. And because the subsidiary is no longer there, so the case was filed against the parent company, that is KPLC. So the key issue in this case was that whether the direct duty of care can be implied in this case, and the parent company CAPE could be accountable, and they should have a duty of care towards this person, Mr. Chandler, who was working in this particular case. Now, the court basically applied the three-limb Caparo test, which, just to recapitulate very quickly, whether the first limb is that whether the injury is or the damage is foreseeable. The second is whether there is a proximity between the two parties, and finally the just, fair, and reasonable approach. And applying these Caparo tests, the court concluded in this particular case that direct duty of care can be imposed on CAPE PLC in this particular case. And the court looked at certain factors, like there was one or two directors which were common. The minutes of the board indicate that there was some control exercised by the company. And more critically, I think there was a group medical officer who looked after the health issues and safety issues for the whole CAPE group. So in view of these factors, basically the court found that direct duty of care could be found in this particular case. I think it may be useful to refer briefly to the test, because I think the critical significance of this case lies in the four-pronged test laid down by the Court of Appeal in Chandler case, and I'm referring to paragraph 80 of this judgment. The first condition, and the court is saying that if these four conditions are satisfied, then the direct duty of care can be implied. The first one is that the business of the parent and the subsidiary should be the same. The second is that the parent has or ought to have superior knowledge about the health or safety of that particular enterprise in the particular industry. The third condition is that the subsidiary system of work is unsafe, as the parent company knew or ought to have known about this particular thing. And the final and fourth condition is the parent should have foreseen that the employees are going to rely upon it. So these are the four limbs of the test that the courts have proposed. Now, the significance of this judgment lies that from the victim's point of view, it is not necessary anymore to pierce the corporate veil. And the court very clearly differentiated that we are not piercing the corporate veil. We recognize that CAPE Products was a separate company and CAPE is a separate company. But in terms of the outcome, basically there is no difference, because you are able to reach the parent company, and that's why I'm calling it Chandler bypass, because you're bypassing the complexity and the difficulty of piercing the corporate veil in this particular situation. In the context of Europe, the issue of FNC, forum non-convenience, is not relevant anymore, but this judgment will have significant implication outside Europe. because FNC will become irrelevant. If there is a direct duty of care on the home estate where the company is based, then FNC, let us say the courts in Australia or elsewhere in Canada, US, or in India, Singapore, other countries apply this approach, then FNC is going to become almost useless. So these are significant advantages of this Chandler approach. At the same time, in my view, there are limitations. For instance, this action was based on negligence. Now, in many cases, negligence or nuisance could be a robust remedy to deal with cases of human rights violations of environmental pollution, but they might not be sufficient in all cases, and that's why that has to be understood. Also, if we look at the four conditions, the court is mentioning that the relevant business should be the same. Does it mean that in a given case in future, if the subsidiary and the parent company are having different kinds of business, which is not improbable, then will the test not apply? The second limb of the test is superior knowledge. But sometimes the superior knowledge may not be there. And then again, the implication might be that the test will not apply. So I think, in my view, Chandler represents a very significant positive development as far as the plaintiffs or the victims are concerned when it comes to violation of human rights or environmental pollution. At the same time, we should not overestimate the usefulness of this test. And there's already some critique of this test that the court is very amorphous about it. And will it apply, for instance, to the cases dealing with creditors and all this, or will it be limited to safety issues and all this? So there are already critique on those particular lines. So my proposition is, and I will conclude with that it may be useful for the corporate law to lay down within the statutory provisions, whichever jurisdiction we're talking about, a statutory presumption. And the presumption should be that the parent company should be liable for human rights violations or environmental pollution caused by its subsidiaries in the entire group, wherever they are operating, unless the parent company can show that it did not know or it ought not to have known about that particular situation. Or the alternative could be that it knew about it and it took due diligence measures. And despite taking those due diligence measures, violations took place. So, unless the parent company is able to satisfy this presumption or reverse the presumption, let me put it like this, parent company should be held accountable. Now, we are not saying that the parent and subsidiary become one for all purposes. What we are saying is that in this particular context, this presumption is raised, and the parent company can always displace it by providing the evidence. Uh, and similar to situation of vicarious liability, it should also be possible for the parent company to recover the compensation, part of it, from the subsidiary. So the principle of attribution could come into picture, and the parent company can always recover part of this compensation, which it might have to pay to the victims from the subsidiary. But that is internal. Why should victims suffer and litigate for 10 years and 6 years and spend so much money? It is internal business of the corporate group. The parent company must pay the victims. And I think because the several states in future are likely to draw their national action plans to implement the guiding principles. So I think we could plug this issue of corporate reform in that particular context. So we could encourage states to consider this question and make this presumption statutorily in their respective corporate laws. And I think this will be consistent with the very idea of corporate groups, because we cannot let companies have both ways. Either parent and subsidiary are different entities. And if they are different, then they should be different both in terms of liability as well in terms of benefits. We should not let the group accumulate all the profits and say, oh, we are such a large group. On the other hand, if they would like to be treated as one group, then they should also be for the purpose of human rights violations and the pollution of environment and all these matters. So perhaps I will stop here. And if there are any further questions or any comments, I'll be happy to take those. Thank you very much for your